Good afternoon, everyone. I'm happy to welcome you all to our annual celebration of Constitution Day. And I just want to start by recognizing the Office of the Provost here on the Bloomington campus for supporting this event, and also our school's chapter of the American Constitution Society, as well as its faculty advisor, Professor Johnson, for co-sponsoring our Constitution Day events. In addition to this lecture, we have a number of students out in local elementary schools participating in the Constitution in the Classroom program. I want to just flag the next item on the ACS calendar, which is a speaker series to celebrate the 50th anniversary of Gideon versus Wainwright, so please stay tuned for further information about that. Our distinguished speaker this afternoon is Professor Jeff Powell. Professor Powell holds a bachelor's degree from St. David's University College of the University of Wales, a master's degree and PhD from Duke University, and a Master's of Divinity and JD from Yale University. He is a member of the faculty at Duke Law School and has held visiting positions at schools including the University of North Carolina and Yale. Professor Powell has also served in a variety of positions in federal and state government, including as Principal Deputy Solicitor General in the Justice Department, and more recently as Deputy Assistant Attorney General in the Office of Legal Counsel, which provides legal advice to the President, the Attorney General, and other executive branch officials. Professor Powell is a leading expert on the role of the Constitution in the activities of the legislative and executive branches of the federal government, and has written extensively on the separation of powers, the President's authority over foreign affairs, and the war powers. He has a forthcoming book entitled The Constitution and the Commander-in-Chief. Today, he will be talking to us about war powers under the Constitution and the question of Syria. Please join me in welcoming Professor Jeff Powell.
Well, thank you very much, Dean Bucksbaum. I want to thank not just the dean, but the law school and all faculty, the Office of the Provost, and the American Constitution Society for having me here today. It's an honor and a privilege. Before I turn to my main topic, I want to draw our attention very briefly to a part of Constitution Day that I think is important, but it's easy to overlook. When you and I mention the words, the Constitution, I think we almost always have in mind the Constitution of the United States. But of course, that's not the only Constitution in the United States. This past weekend, I tried to figure out exactly how many constitutions there are in the U.S., and I think it's around 615. In addition to the federal Constitution, there are, of course, the 50 state constitutions. There are 2 commonwealths with constitutions. There are 3 territories in the District of Columbia that have documents that are in effect constitutional. And there are about 330 federally recognized Native American nations and 230 Native Alaskan villages. All of these political communities are, to some extent, autonomous, separate. All of them have constitutions, most of them written and many of them called constitutions, and all of them contribute both to the shared commitment of this republic to constitutional government under the rule of law and to the diversity of this republic. So in thinking about what we celebrate today, let's not just celebrate the U.S. Constitution, but celebrate all of our constitutions. Now, that said, I want to focus today on the U.S. Constitution. The date of this celebration is, of course, set by the fact that on September 17, 1787, the framers signed the document. Well, most of them signed it. I think 3 of them stuck it out to the end and then refused to put their names on it. In any event, what is the Constitution? The U.S. Constitution. What are we talking about? The very fact of this date suggests that this is the answer. It's a document. Well, actually, it's a set of documents. The big long one at the beginning is the one signed in 1787, and then there are much shorter ones that have been put into the Constitution through the amendment process at later dates. But any of that, one answer, and it's an answer that's true as far as it goes, is that the Constitution is this, the document, our governing instrument. However, to stop there and just say it's just a document is to, I think, be too brief and to ignore central truths about the American Constitution. It's not just a document. In fact, the document itself suggests that there's more to it than just what was done in 1787, 1788, and 1789 as it came to be the supreme law of the land. Because the Constitution provides for its own change through the Article 5 Amendment process. But that's not chiefly what I have in mind. I think when we think about the U.S. Constitution, we need to realize that what we're talking about is not just a document, but we're talking about a conversation. We're talking about a debate. We're talking about a tradition of how to think and how to argue and how to discuss and how to decide fundamental questions about how this republic governs itself. At the heart of the tradition and central to the conversation is this, the document. But the conversation is the ongoing way in which the U.S. Constitution, the document itself, becomes a reality. Now, quick footnote for constitutional law aficionados. I am not taking sides in the originalism, living Constitution debates. I take no position here in this talk about who's right on in those debates. I'm simply making an observation. When you talk about the Constitution, when you talk about, I said living without the take sides, when you talk about the conversation that we actually have, whereas while the document is central, the conversation is never just about the document. It's never been just about the document. As if you could take that in a dictionary, and that's all you would need. Much more has gone on. And what I want us to do today is I want us to celebrate the U.S. Constitution by thinking about how it is we carry on this conversation. What is it we do when we try to resolve these fundamental issues through debate centered on the text, but going beyond the text? Now, a lecture is not a good model for a conversation. I'll try to leave some room at the end for questions and answers. But I'd like you to think about the lecture or the talk as if it were a conversation. It's me talking to myself, and you're something like that. All right. Now, since this is Constitution Day, and since that's a day that brings us together, not to indulge in divisive, partisan, contentious issues, I thought to myself after I got the invitation, what can I use as an example of the constitutional conversation that won't get people riled up, that won't have people in disagreement, that we can all be happy and content about. And of course, the first thing that occurred to me, war powers in Syria. This way I won't get into any trouble, so no one will get mad at me. Well, maybe not. But of course, there's an advantage from my perspective, even what I want to say today. There's an advantage in choosing a contentious and I think very difficult question. The advantage is, I believe that central to what we are celebrating today is the fact that the American Republic created, through the document, through what we've done with the document, created a conversation about fundamental political issues on which we disagree. We don't need to have a conversation when we all agree. What we need to talk about is where we don't agree. And of course, if you don't talk, the other ways of resolving fundamental political disagreement are unattractive in the extreme. And what we celebrate today is in large measure the fact that we have succeeded. There was one big lapse between 1861 and 1865. But we have succeeded in transferring fundamental political disagreement from battlefield, and even, at least much of the time, from the shouting match to a conversation. And we may not end up agreeing at the end of the conversation, a little bit of it we do at any given time, but we're engaged in a conversation with one another. And that's, to me, one of the central things that we celebrate on Constitution Day. All right. Well, let's think about the question of intervening in Syria. There's not just one question. I always tell my first year students that one of the things you need to do in order as a lawyer is to be clear about what you're thinking about. Be clear what question you're asking. And there are many questions to be asked about intervention in Syria. There's an humanitarian question. What can we do about the horrible suffering that is being undergone in that country? There's a moral question about what is legitimate for the United States to do if we want to respond to the humanitarian crisis. There's an international relations question. What will the world community do if we take action? There's an international law question. Is it lawful under the UN Charter, under customary international law, for us to do something? There are strategic issues. Is it wise for the United States, looking at things from its own perspective, to take action? And there are domestic political issues. What will the American people stand for? What do the American people want? Those are all great questions. They cannot be isolated or separated out from one another. They overlap, but they are distinct, and they are distinct from the further question, which is the one I'm going to be talking about, which is the question of law. The specific question, under the U.S. Constitution, of who has the authority, the lawful authority under the Constitution, and under what circumstances to order the United States Armed Forces to take action against the Assad regime. That's the specific question I'm dealing with. Well, why leave aside these others? We leave them aside only in the sense that we focus on a particular question. In my case, the constitutional question. Not because it's the most important. I don't think it is. I don't think legal questions are ever the most important questions. There are more important ones. But legal questions are always important under our system of government. They cannot be avoided. They must be answered. That's what I want to talk about today. How it is we go about trying to answer this question. Who has lawful authority in our law, and under what circumstances, to order a strike against the Assad regime? All right, so that's the question. Let me immediately acknowledge two difficulties in trying to think about it. The first is that I suppose many Americans will think, well, if you want to answer the question, who's got the authority? Is it the President, or is it Congress, or is it the President plus Congress, or is it the Supreme Court? They say, well, you can look. Well, when you look, and I'm going to say more about this in a couple of minutes. When you look, you find things that will help a lot in trying to come up with an answer. But I don't think you will come up with a clear-cut answer in itself just by looking. Yes, Article 1, Section 8 of the Constitution says that Congress shall have the power to declare war. Yes. Article 2, Section 2 of the Constitution says that the President is the Commander-in-Chief. But those two clear statements don't clearly answer our question. Does Congress's declare war power mean that it must decide on hostilities? Does the President's Commander-in-Chief authority mean that he may make the decision on his own? Do they need to work together? Those are the questions we actually need to answer, and staring at the text does not answer. All right. My second preliminary point, illustrating the difficulty of the issue. Well, I'm going to tell you a secret. Can we turn off the recording? I don't want this leaving the room. All right? When practicing lawyers who deal with constitutional questions get a difficult issue like this one, this is not the first thing that actually comes to their mind looking in here. What comes to their mind is, what does the Supreme Court say? What's the case law? What have the justices told us? They look for case law. Well, I teach war powers. Okay, that's the secret. I teach war powers in my first year constitutional law class. And I have my students, I introduce my students to the three leading Supreme Court decisions on the initiation of hostilities by the United States. By the way, let me just quickly say, I'm not talking about attacks on the United States. That's not going to be something I have to do. Everyone agrees that the government, and specifically the president, may respond to an attack. The question on the edges about what counts as an attack, let's put that to one side. All right. There are Supreme Court cases. They don't squarely answer the question, but they address the question in oblique ways about who has the power to decide on hostilities. You know when the most recent one was decided? 1804. The United States Supreme Court has managed for the 200 and almost 10 years since then to duck the question. That doesn't mean it said nothing relevant. But it does mean that the Supreme Court's guidance, because these old cases are hard to read, don't say a whole lot, and the latest is 1804. So the Supreme Court is not going to give us a clear answer. So the usual practicing lawyer's resort, which is to go look at the case law, won't answer our question any more than the text by itself answers our question. That makes it a tough question. It doesn't mean that we either have to throw up our hands and say, well, there's no answer, or just descend to shouting at one another. We can think. This is what constitutional conversation allows us to do. We can think about the issues and debate them in a disciplined manner, even though we may not come to agreement. So I'm going to try to do that. I'm going to try to think through the question about who has the power and under what circumstances to order an intervention in Syria of the sort that is being apparently contemplated. I want to think that through as much as possible with you. Let me start with the easy answers, or parts of the answer. First, can Congress do it by itself? Congress has the power to declare war, so can't Congress just simply say, declare war on Syria and send a copy of the bill to the Joint Chiefs and they will then immediately carry it out? No. I either put the Joint Chiefs in a very difficult position if Congress got to do that, but I assume that they would send a nice respectful note back saying, well, you know, thanks very much, but the President hasn't told us to do anything. Congress, the Congress of the United States, doesn't issue orders of that sort to anybody with exceptions that are not germane. The Congress passes laws, and then those laws require or prohibit action by other people. The Congress by itself, though it could start a war in the sense of declaring it, or authorizing military action, Congress can't actually make that happen. Executive branch would have to make it happen. So Congress by itself can't actually cause the strike to occur. All right. The other easy part of the answer is, well, suppose Congress authorizes military action and the President agrees and then orders the Joint Chiefs, who will obey the President in the matter, to carry that. Is that lawful under our law? The answer, I think, on the part of any responsible constitutional lawyer is yes. Absolutely. Now, it may be unlawful under international law. It might violate the UN Charter, therefore placing the United States in the position of being a lawbreaker. But under our domestic law, the President and Congress decide, for whatever reason they decide, to carry out military strike against the Assad regime. Under our law, I think it's clear that they have the authority. The law question under the Constitution is answered. That one's pretty easy. All right, now let's get to the interesting, difficult parts of the question. And I want to take a time machine. I want to get a time machine for everybody. I want to go back a couple of weeks before the President referred the issue to Congress. I'll come back to that, but let's forget about it. Let's suppose we're back a couple of weeks ago. Congress hasn't been asked anything. Congress doesn't show any signs of doing anything. The question is simply, may the President take unilateral action? May the President, on his own authority, order the U.S. Armed Forces to carry out the sort of attack on the Assad regime? That's our question. All right.
Let's look at the text of the Constitution. Wait a minute, Powell. You just said the Constitution's text won't answer the question. Well, it doesn't answer it fully. I don't think it by itself generates the bottom line, but that doesn't mean that the text is irrelevant. And it doesn't mean the text doesn't point us in various directions. Here, I think, myself, it points us in a pretty clear direction. If you look at Article 1, Section 8 of the Constitution, which is the main list of Congress's powers, you will find not just the power to declare war, but a list, quite a laundry list, of other powers that relate to military and national defense matters. Furthermore, at the very end of Article 1, Section 8, you find the necessary and proper clause, which enables Congress to pass legislation not just stemming from its own powers, but to pass legislation that has to do with the powers of the other two parts of government, the President and the courts. So Congress can enact legislation not just to carry out all the various military powers it has, and it may also pass legislation that has to do with the President's commander-in-chief power. When you put all of that together, my judgment is that it's very hard to say that Congress has no role in deciding to start hostilities. In fact, it looks like Congress clearly ought to have a role, given this long list of powers. Now, some people say, well, but you can parse out these different powers, and the power to make an army is just to create it, the power to declare war is just to announce that we're in a state of war, which is a legal state, and so forth and so on. That you can pull apart all of Congress's powers, and then when they're disassembled, it doesn't mean that Congress really plays a role in initiating hostilities and making that decision. That's not the usual way we treat Congress's powers. I don't think it's the right way to treat Congress's powers. It is not the way the Supreme Court has treated Congress's powers since at least 1819 in the great case of McCulloch against Maryland. When we read Congress's powers, the tradition is to read them as a whole, to think about individual powers in light of overall responsibilities for which Congress is vested. And when you do that, I think this notion that Congress somehow is limited to just announcing the state of war as a legal matter, I think that's not, in the end, persuasive. Well, what about then the clear alternative? Congress has complete and exclusive authority to authorize hostilities. The President carries them out. He issues the orders. But Congress must authorize all hostilities. Isn't that the clear conclusion we should draw from what I said? There are a lot of highly intelligent, learned academics who think that's exactly right. Now, the great John Howard Ely, very, very great constitutional law scholar, once said emphatically and dogmatically, of course, Congress must authorize all hostilities. Not the attack on the United States, put that to one side of it. But if the United States chooses to go to war, chooses to exercise military force, that must have congressional pre-approval. I don't think that's an insubstantial argument, but I don't buy it, and here's quite well. One of the reasons. Do you know who the first president was to decide that he had unilateral authority to use military force as part of his conduct of foreign policy? Anybody know? George Washington. The assertion and the conclusion that in the carrying out of U.S. foreign policy, Washington was the first president to say, that's my responsibility. The conclusion that in carrying out foreign policy, the president may, among other tools, make use, at least to some extent, of military force. That's a conclusion that began with the first president and has continued throughout history. Now, you can say, and this is what Professor Ely said, you can say, well, they were all wrong. And every president who did that was violating the Constitution. You could say that, and I find it utterly unpersuasive. The Constitution is not a text for theoretical discussion among academics. It's a practical instrument of governance. And how we, the people, have permitted it to be administered and understood over 2 centuries plus is a very weighty consideration, and I just don't buy it that every president from Washington on down has violated the Constitution and his oath. I find that unpersuasive. So it's not that Congress has exclusive power to initiate hostilities, in my view, and it's not that Congress has no power. Is there a median position? Yes. And it is, for a long time at least, been the executive branch's considered view, with an interruption in the midst of that. This view was articulated in the modern era by great opinion by Assistant Attorney General William Rehnquist, who went on from being a presidential legal advisor to being Chief Justice of the United States. In 1970, Assistant Attorney General Rehnquist, and again in the 1990s, Assistant Attorney General Walter Dellinger, a very distinguished living constitutional lawyer with whom Professor Johnson and I worked. Dellinger repeated Rehnquist's basic position, and I think it's the right. I'll tell you why. The Rehnquist-Dellinger position is that in carrying out the President's responsibilities for foreign policy, conducting American foreign affairs, the President has available as one of the tools of foreign policy the use of force. There must, of course, be good reasons, but those reasons would be foreign policy reasons, and those are within the President's discretion and judgment. And furthermore, there's a limit. Precisely because, as Rehnquist wrote in 1970, the framers clearly intended to divide the war powers and distribute them among the 2 elected branches. Precisely for that reason, you can't just cut Congress out. And the way you need to make sure that Congress is included is that the President must recognize that at some point, his authority or her authority to carry out military action pursuing foreign policy objectives, at some point, the projected operation, projected use of military force will become so large, so broad in scope, or anticipated duration, or a number of casualties suffered, or a number of casualties inflicted, or in severity and intensity in other ways, at some point, the President must conscientiously decide this is war in the constitutional sense, and as such, it must be authorized by the Congress. I can't do it on my own. In 1970, Rehnquist said, after the Vietnam War, it had not been constitutionally, congressionally authorized. Rehnquist said, he put it tactfully, but what it amounted to was, it would not be lawful. We needed Congress because it involved hundreds of thousands of U.S. troops, thousands of U.S. casualties, many more thousands of Vietnamese casualties, and on and on. So the President, under this rule, the President must decide that there's a good foreign policy objective and that my use of force, as I anticipated, will not rise to the level of war. Objection! This rule, imagine scare quotes around the word rule. This rule is no rule, because, of course, presidents will do whatever they want. They'll look at the lawyers then to cook up some document that satisfies whatever the quote-unquote rule is. But you're assuming, Powell, you're assuming that presidents act in good faith and conscientiously, and that's ridiculous. Guilty as charged. The American Constitution, as often said, is based on suspicion, on the fear of power, and that is true. That is why, among other things, we have divided governmental responsibility into 3 independent branches. But American constitutionalism also depends on the assumption of good faith and conscientious behavior on the part of those vested with power. And the system would grind to a halt if we did not act on that assumption on a daily basis in all sorts of ways. We assume good faith, we assume conscientious behavior, when we find that our assumption is not being fulfilled, we ought to do something about it. We, the people, we have electoral and other tools to deal with the political branches. The judges are harder to deal with. It's a judge in the audience, so I need to be careful here. We assume good faith. All right, so I'm going to just live with this objection. You're right. You think it's a conclusive objection. You don't buy the Rehnquist-Dellinger position, but I think you're right. That's part of the constitutional conversation. All right. Second objection. This rule, scare quotes again, this rule is too fuzzy. It's too open-ended. Well, okay, World War II is clearly a war constitutionally. Vietnam is clearly a war constitutionally. They go on for years, and there are hundreds of thousands of U.S. troops involved, boots on the ground, and there are thousands and thousands of American casualties. And sending a single frigate into the Persian Gulf at the risk of somebody taking a pot shot at it, that's probably not war. Okay, I can see on the far ends of the spectrum, what's war and what's not war, but when I get closer to the middle, it gets tougher. Suppose the Syrian intervention is projected to take 2 weeks and involve 5 cruise missiles. Yeah, doesn't sound like war to me. Suppose it's going to take a year and involve pounding the heck out of the Syrian infrastructure. Well, sounding a lot more like war. And then, of course, you know the game. You probably played it in first year classes. I've moved you closer and closer. What about 7 months and a lot of cruise missiles? What about 5 months and fewer cruise missiles? We can play that game. The point of the objection would be, this is not a rule because it involves too much of a judgment call. What do you say to that, Powell? Guilty as charged. Of course, this principle, let's call it that if it makes you happier, this Rehnquist-Dellinger principle, of course it involves the exercise conscientiously of judgment. But law is full of that. Constitutional law is full of it, but it's not just constitutional law. We deal with these kinds of judgment calls and deciding where a line has to be drawn because it has to be drawn somewhere all the time. We should have known that at least since Justice Holmes, who said repeatedly, differences in law are regularly differences in degree, not in kind. They're differences between points on the spectrum, from the single frigate to World War II. So, I'm not bothered by that. Well, but isn't that too freeform to be legal thinking? Aren't you ignoring the difference between lawyer thinking and, you know, what the Joint Chiefs presumably did? I don't think so. I don't think we're talking about purely freeform. It looks like law to be. I made it sound that way, didn't I, a moment ago? That's not really what I think. When the president and his advisors apply this rule, they ask themselves, okay, the Joint Chiefs say that it takes this long probably to shut down the Assad regime's ability to use chemical weapons. This is what it'll take, this is how long it may take, you know, probably casualties, etc. And then the president and his legal advisors have to say, well, now, I accept the Rehnquist-Dellinger rule. Does this amount to war or not? How other than just, you know, sort of making a freeform judgment, how do you do that? Well, you do it the way you make lots of decisions in law in a common law world. You look for analogies. You look for what it's like. It's not much like World War II. And it's not really, to my judgment at least, a lot like the single frigate, which isn't going to be shooting at anybody unless it gets shot at. And then you look at things that may be closer. You look at things like the Libya intervention. You look at the Kosovo air war. You look at other instances in which presidents have unilaterally used military force. You ask yourselves if the president was justified in doing it then, and you ask yourself, how analogous is that situation to the one that we're dealing with now when we think about Syrian intervention? So, yes, there's a judgment call here. Yes, it requires good faith and conscientious thought on the part of the president and his advisors. But neither one of those bothers me because both things, judgment calls and good faith, are required in the law again and again. and again. All right. Let's take then this rule and apply it to the Syrian matter. We've all got some picture at this point, if you've been paying any attention at all to the news, about the kind of level, in some, at least broad sense, of action that seems to be contemplated. We've been told emphatically no boots on the ground. We've been told emphatically no long-term commitments of the Afghanistan-Iraq sort. We've been told a variety of things about how this will be air attack, an attack on military assets. We've also, of course, been told that the administration agrees, understands that the Assad regime is trying to hide things, but in the middle of civilians, so the collateral casualties increase. So we take all of this, and then when we have all the information with the president and his advisors, and then we come to a judgment call. What is this most like? What seems most persuasive? Do I think this has to be treated as if it were a war that needs Congress's support? Remember, it was 2 weeks ago when the president hasn't referred the issue to Congress. What's my answer? My answer is, I probably need to know more to come to a firm judgment, because I need lots of information. I need the policymakers to tell me as their lawyer what they plan, what they anticipate. And only then can I feel comfortable in my legal judgment. But, well, I'll see if anybody asks me what my judgment is during the questions and answers. Maybe everybody will forget and I won't have to say. All right, going right along to another topic. Let's get back in the time machine and let's come to the president. The president has referred the issue to Congress. He's asked Congress to authorize military action. Let's suppose Congress, as it seems possible, Congress doesn't act. Now, Congress, of course, could respond to the president by passing a bill that forbids the president to act. And that bill would go to the president's desk, and the president would veto it. And the veto would be sustained. So I suspect that even if you thought that's the right thing for Congress to do, you might not waste much time doing it because it won't work in the end. So that's probably not the scenario. The scenario that's being debated right now is that the president, having referred to the issue to Congress, finds that Congress doesn't say yes, but it doesn't pass a no either. It doesn't pass a no because a majority doesn't want to authorize the president, but they don't bother to pass anything. They say their no, they articulate their no by doing nothing. What about that? Suppose that happens. The Secretary of State appears to repeatedly have said that in that circumstance, the president will still have unilateral power. Let's assume that the Rehnquist-Dellinger rule leads us to conclude the president could have acted on his own with that before Congress got involved. But can he still do so when Congress has been asked and is not said yes? That's one of the toughest current-day questions in constitutional law. And the fact that it's tough, and therefore, what defines a tough question is that reasonable people can in good faith disagree. It's a tough question, and therefore, people can disagree about it. That doesn't mean that we can't come up with some way of discussing the question. And here, I think it's quite clear what we have to do to think about. Can the president act if Congress doesn't under current circumstances? There are two cases that seem to me relevant, and whichever one controls gives us the answer. One of the cases is Youngstown, the great 1952 steel seizure case. Several of the concurring justices in the majority, including the two who wrote the most influential concurrences, Justices Jackson and Frankfurter, based their conclusion that President Truman could not seize the steel mills during the Korean War, in part at least, on the fact that the president had asked for the authority to do what he did in the past, and Congress had said no. Or rather, Congress had not given him the authority. Congress had just not answered because it didn't want to do what the president preferred. It didn't pass a prohibition, but it did provide the authority. That's our situation. Those influential concurring justices in Youngstown said, well, that's as good as a no. The president ought to take that as a no. And therefore, this is Congress having used its power to say, no, you may not do this. If that's the appropriate case under which to think about our scenario, then I think the president needs to respect inaction by Congress as if it's a no. All right, the other case is the 1983 case, the Chadha case, the case that invalidated legislative vetoes. In Chadha, the Supreme Court said, with exceptions that are not relevant, that Congress, if it wants to control what goes on beyond its four walls, it has to pass bills and present them to the president. Only when it does so is Congress's will legally efficacious. If Chadha controls, then mere inaction on the part of Congress isn't enough. It's just enough. It's a nullity. And therefore, in that situation, in that case, if, having referred the issue to Congress, before the president referred the question to Congress, if he had the authority, then Congress's inaction wouldn't change anything. He would continue to have the authority. So while this, I think, the most contentious of the various issues in this matter, legally, I think it depends on whether you think Youngstown controls or Chadha. I have my view, but once again, I will see if I get nailed by someone during questions and answers, and if not, then I will have to keep my opinions to myself. I want to say two more things, and then we'll stop for questions and answers. All right, why not leave this up in the courts? I mean, isn't that what we like to do? A very distinguished person who I admire in many ways said during congressional debate over the Equal Rights Amendment that he was asked, well, what will the amendment do? And he said, well, I don't know, that'll be up to the Congress. That's, of course, sadly a ridiculous answer. You need to know what it is you're doing. You can't leave it up to the Congress. But in any case, remember when the last time the Supreme Court tried to address a question close to ours was? 1804? We're not likely to get an answer. We can't leave it up to the courts. And we shouldn't leave it up. But that's not happening. And the final thing I want to say is that what I tried to do in this monologue is model, and I don't mean model in the sense of doing a good job, but model in the sense of giving you an example of what we need to do and what we have done successfully for most of the history of the Republic, which is think not just in a free-form way, not just shooting from the hip about these fundamental questions that the document seems to address, but rather to think in a disciplined way, trying to figure out what's analogous, trying to figure out what the relevant parts of the text are, trying to figure out what history tells us, what the traditions of our law and our people, as Justice Holmes once said, tell us. We've tried to debate these issues using these resources, and that's a good deal different than just shouting at one another or than shooting at one another. It's a conversation. And it's that conversation that we celebrate today. You've been very patient, and I appreciate it. Questions? Seeing none. Yes.
When lawyers reason by analogy, they generally start from a fixed point, a precedent that is settled, and then they figure out, is this new situation alike or unlike that? If I understand you correctly, you suggest that we evaluate a situation like Syria. Let's assume you had all the information you wanted. Then I think you said you would look at previous similar examples and analogize this situation to those. But how do we know, in terms of undeclared wars, presidential interventions, what is a sound precedent? What's our fixed star or our precedent that we give? Is it based on whether it was successful or unsuccessful. It's should we look to Libya, Grenada, Panama. In other words, there are plenty of examples we can look to measure this against, but those also typically lacked a sort of clear basis in whether it's declared war or not. It feels like we're having sort of inference on inference. So the basic question is how do we figure out what is a sound precedent to measure the current situation by?
That's a fabulous question. And it's one reason why, despite the importance of the legal branches taking action and us paying attention to the history of what they've done, that's why judicial resolution is so oftentimes advantageous, because it actually gives us, at least that moment on that matter, a clear answer. Lots of times. I totally agree. My answer is that we can't avoid the kind of uncertainty. We're floating on the sea, on the raft that we're building, even if we're floating. But I think we can make some headway. I think we can clearly see issues. Well, let me give you an example. One, it's very difficult to make sense of the Korean War as a legal matter. It's very difficult under any position other than one I haven't mentioned, because I think it's totally unsupportable, which is the president may use any level of military force, any kind he wants, for any purpose he wants to use it. I don't think that's acceptable, and I don't think the Korean War can be defended otherwise. What about other things? Do we have other examples? Well, the best examples we could find would be ones where one of the political branches seems to have conceded that, in the case of the president, the executive lacked the power, or in the case of Congress, the president possessed the power and acted unilaterally. We can find some examples. I'll give you one. It wasn't the president, but it was one of his chief legal advisors, Rehnquist. Rehnquist conceded in his 1970 opinion that Congress's limitation of the Vietnam War by forbidding the use of force in Laos and Thailand, he conceded that that was, in fact, to be obeyed by the executive. So that extension of the Vietnam War, which I take it, he doesn't give us a lot of detail, but I take it what he's concerned about is that it extended to new places, the conflicts were not involved in, and where the experience of the places we are involved in lawfully, which is to say essentially South Vietnam, is that boots on the ground and extensive and long-term military operations follow along. So I would put a lot of thinking, I would address a lot of thinking to the question of what that means. Or again, going the other direction, I would like to know, and we don't know publicly, the rationale that the Clinton administration had for unilaterally acting in Kosovo. The Kosovo operation wasn't years and years, and it was remarkably free of American casualties, but it was not free of Serbian casualties at all, and it involved the infliction of a tremendous amount of damage on the Serbian infrastructure. Maybe that doesn't fit under the Rehnquist-Dellinger rule. Maybe that was unlawful, and that's a cautionary thing that we should avoid. So that's the kind of thing I would do with your major point is powerful, and there's no clear answer. It's, I think, part of the uncertainty involved in various the courts won't give us answers. But we must have an answer, and the answers must be answers that come from law. Because the question of who has the lawful authority is by definition a law question. Yeah.
At what point under a President office has Congress not acted, as opposed to just not acting reacting? How would you even determine if you were not going to use that analysis? When Congress is taking a long time debating, hasn't voted a vote yet, those votes are in the vote, they haven't acted yet, versus they've actually, by not acting, said no. For Justice Jackson, Franklin, or not.
Right. Great question. I suspect, this is kind of like Justice Stewart talking about a different issue. I know it when I see it. If Congress is still in the process of debating, in some sense, then clearly we haven't gotten an inaction that ought to be paid attention to by Jackson and Franklin. If it's clear that the issue is dead now, on filibuster. If it's clear that the issue is dead because it's going nowhere, the president will not get a yes, then I think we've got what Jackson and Frankfurt would treat as automatic. And the filibuster, the only possible way for a constitutional lawyer to respond to filibuster issues is to hide. I guess since the Senate won't get rid of it, that's the end of it. That's the end of it. So that's a no as well under Jackson and Frankfurt. That's fine. Yeah.
Is there any precedent in which a president has, like President Obama, explicitly requested congressional authorization for the use of military force, not received it, and gone ahead anyway?
That's a great question, and I think the answer is no. Does anybody know what Congress? I don't think what Congress has. Part of that is because modern presidents haven't tended to ask. Yes.
Yes. You began by isolating, in a sense, the legal aspect from some of the elements of context. But I want to invite you to go back and consider three elements of the context, whether in a close call they shouldn't influence even our view of the legality. One is that maybe more even than Kosovo or Libya, Syria involved potential for complications and escalation. So whatever the president's intent, because it was a potentially regional war, the president could not be certain that hostilities would stop or that circumstances wouldn't arise obliging him to use American forces and involve American casualties. The second one, which you said didn't have bearing on American law, but is the question of those international legal obligations that we've entered into because we're a party to them. I mean, we're part of the United Nations system. And if something were contrary to Article 51 of the UN Charter, wouldn't that have legal implications for us? The third, and the fuzziest of all, but rather clear in the balance, is public opinion, where we have huge majorities across the political spectrum. And although we don't live in a referendum system, we still do live in a system of democracy in some sense. Obviously, those influence the political decision that the president made, but do they also, in your view, influence what would be wise lawmaking?
Okay, those are great questions. As to the first, complications and so on, the United States Constitution has no clause saying that Congress and the President shall do no stupid things. Congress and the President have the power to do stupid things, many immoral things, many things I think abhorrent, and yet they have the lawful authority to do it. So the mere fact that they may be wrong in a ghastly fashion, which may be true, about the possible complications doesn't change my analysis of the law. And indeed, how could it? Because the underlying issue here, in part, underlies your great questions, is we're talking about law, and one reason for isolating that out is because we're isolating out law so we know when to listen to the lawyers. When I speak to you as a constitutional lawyer, well, I may have persuaded you that you shouldn't pay much attention. But if I didn't do that, then you might say, well, you know something about that. If I talk to you about my views about the result of the American strike against the Assad regime on Middle Eastern politics, there's no particular reason why you should care what I think, because I have no expertise. So I shouldn't fool my client into thinking that I can bring to bear on her questions expertise I don't have. And that's true of the President's logic as well. All right. Second question, international law. The United States may well, for all I know, as far as I'm going to say, may well be in violation of the UN Charter if it unilaterally strikes. Then the United States will be a lawbreaker. The United States will then be subject to international law sanctions. It doesn't change the domestic law consequences or considerations. See Medellin against Texas. Our law is distinct from international law. The United States accepts its place in the community of nations and therefore the binding force of international law, but it's binding in its sphere and the remedies are to be applied in its sphere. But of course, the other remedy is you and me, the political remedy, the response. If you and I don't like what the government does because, among other things, it violates international law, then we should do something about it. All right. Your third question, public opinion. I think the President and Congress will take account of public opinion. And in analyzing what their lawful authority is, I don't think I need to take that into account. And indeed, once again, I don't think I should, because I have no expertise on public opinion. I can read the polls. The President told us recently that he reads the polls. I'm quite confident that's true. I don't bring anything to bear valuable when I, as a lawyer, speak to them. And I don't think the law has to do with that, because, as you correctly pointed out, we don't live in a plebiscitary democracy. I have time for one more, maybe? Professor Johnson.
How would you apply the Rehnquist-Dellinger analysis?
And you're right, I am. To which? To what? Yes, sir.
To the extent you have them.
I do have it. But it is uninformed, because I don't know anything more. Well, some of you may know a lot more, because you may be experts in the field, relations or whatever. As a citizen, what it sounds like to me they're talking about cannot be closed in, cannot be defined in the closed-in fashion that the Rehnquist-Dellinger rule requires. I don't see how, myself, you can think that we can be confident at all that it'll take just a month and some surgical strikes. Particularly not when the government, people in the government say things like, well, we don't engage in pinpricks. I'm not persuaded, therefore, that what we have been, what I understand myself, ignorantly, be the facts, to be the prognostications of the experts, the military, and so on. I'm not convinced that what we've been told shows us that this is below the level of war. So based, this is just in response to my friend's question. In a situation where I don't know enough, if I were actually still in government, I have to say, you have to tell me more. I'm stuck with this amount of information. I'm saying I can't come to the judgment that this is a war. And therefore, you haven't persuaded me that you have authority to act on it. But that's worth exactly what you all are paying for. Thank you so much. I appreciate your time.
If any of you have these assignment sheets, you give them to me. Or like,